Thanks everyone for coming, especially on such a dreary day out here. Food is en route, so I will appreciate your patience for waiting perhaps halfway through when it arrives. Hello, my name is Josh, and I'm the president of the Harvard Federalist Society. The Federalist Society is a group of conservative, libertarian, and moderate law students that stands for three principles. The state exists to preserve freedom, the separation of powers is central to our Constitution, and it is in fact the province and duty of the Judicial Department to say what the law is and not what it should be. Now I'll turn it over to Trent to introduce our speakers.
Thank you all for coming. As usual, we have the sign-in link on the board. We're thrilled to have with us today Professors Tribe and Balkin to discuss whether Ted Cruz is eligible to serve as President of the United States. Professor Laurence Tribe is a graduate of Harvard and also Harvard Law School. He clerked on both the California Supreme Court and the United States Supreme Court, and at the age of 30 was tenured here as a professor. He's been teaching here since 1968, and in fact, he taught Ted Cruz while Senator Cruz was a student here. And his writing and practice of constitutional law has had a tremendous influence on the field over the past few decades. Responding will be Professor Jack Balkin. Professor Balkin is also a graduate of Harvard and Harvard Law School. After law school, he clerked for Judge King on the Fifth Circuit, and then spent time in private practice at Cravath. And he now serves as a professor of constitutional law at Yale Law School, where, among other things, he's developed a theory of living originalism. Please keep in mind that this event is being recorded. It's being live streamed right now and will also be posted on the HLS website later. And with that, please join me in welcoming our guests.
Thank you very much, and thank you for being here. There will be, I'm told, a lunch during some kind of break between our two sort of little talks, and hopefully there'll be time for Q&A at the end. So how does a Canadian law student, born to an American mother and a Cuban father, by providence impoverished, grow up to be a hero and a scholar, and climb so high, so fast that he can come within arm's reach of the US presidency? By being a lot smarter, by being a self-starter, and all that good stuff that Lin-Manuel Miranda has Aaron Burr sing about Alexander Hamilton in the opening hip-hop number of the smash hit now on Broadway. But unlike Hamilton, who had been born in St. Croix but qualified as a citizen of the United States at the time of the Constitution's adoption, Ted Cruz can point to no grandfather clause exempting him from the Constitution's specific requirement that a president be a natural-born citizen. That's a term the framers very likely, though no one is absolutely sure, used to mean more than someone who can claim only statutory citizenship at birth without subsequent naturalization under the federal laws that were in force at the time of that person's birth. Rather, it meant someone whose birth in the US automatically and irrevocably conferred a natural status as a US citizen. Distinction between natural and statutory that sounds odd to modern ears, but didn't sound odd to them. I wish I could say that I had focused like a laser on that constitutional obstacle to Ted's unconcealed ambitions when he was my very bright and opinionated con law student here in 1994. I've had some ambitious law students, Barack Obama being another one. But I don't suppose anybody at the time actually envisioned Ted as a potential president. It was only as Cruz climbed ever higher up the political ladder that anybody, including me, began to take seriously the seeming contradiction between Ted Cruz's Canadian birth and his emerging presidential aspirations. By the time Ted surfaced in the political arena as part of the Republican legal team in Bush versus Gore, in which I was part of the Democratic team, no crystal ball would have been required to see the eligibility problem that Cruz would have to overcome if he were to crash through the Canadian glass ceiling that otherwise kept his ambition in check. As Solicitor General of Texas, Cruz filed briefs in major Supreme Court cases, well-written briefs, in 2007 and 2008, quoting me, as it happened, and singing my praises as a, quote, prominent constitutional expert, unquote, whenever he could invoke something that I had previously published, whether in or out of context, to bolster his Second Amendment or 10th Amendment views. Maybe he thought aiming a kind of flattery at his former professor could deter a liberal like me from getting in the way of his climb to power. Who knows? I suppose Cruz was relieved when he saw the 2008 memo that John McCain had asked me and Ted Olson, who had been George W. Bush's Solicitor General, to write. He asked us to evaluate the impact of his birth in Panama on his presidential eligibility. In our memo, Olson and I concluded that being born abroad did not automatically disqualify McCain, because unlike Cruz, McCain was born on U.S. territory, the Panama Canal Zone. And again, unlike Cruz, McCain was born to two U.S. citizen parents who had been deployed to the zone by the U.S. military to serve their country. Throughout our history, from before the founding to the present, it's been traditional to regard children born abroad to citizen parents serving the nation as soldiers or as diplomats, as though they had been born within the nation's territory. Now, Cruz obviously wants everyone to overlook those controlling distinctions. Having conveniently renounced his Canadian citizenship shortly before tossing his hat officially into the presidential ring, Cruz has been handing out the memo that I co-authored with Olson to all of the media to prove that my expressed doubts about his presidential eligibility should be ignored, because he says they're inconsistent with the memo that I wrote for McCain. For good measure, he dismissed me as just another left-wing judicial activist who had been Al Gore's lawyer, he says, in Bush v. Gore. That part's true. And worst of all, who was a Harvard law professor. He talks as though Harvard, Princeton, all those elite places have nothing to do with his own past. Although it's said that when he was a student here, he would not allow anyone from a non-Ivy League college to join his study group. But I digress. It was his view that my constitutional opinions must have been driven not by principle, but by hypocritical admiration for McCain as a moderate hero, coupled with some kind of dislike for Cruz as a conservative anti-hero. I don't know where he got the idea that I disliked him. He was a fun student to have. I enjoyed jousting with him. Anyway, talk about the pot calling the kettle black. The only constitutional hypocrisy that I can find in this picture belongs to Ted Cruz himself. In fact, my main interest in his claim that he's a natural-born citizen is not so much in whether he can or cannot serve as president, though that matters a lot. My main interest is what the claim tells us about conflicting approaches to constitutional interpretation and what I would call fair-weather originalism. As an unapologetic living constitutionalist, I'm someone who believes, not necessarily a popular view in the Federalist Society, that even constitutional terms of art, like bills of attainder and natural-born citizen, not to mention the more obviously open-ended terms, can be flexible enough to accommodate changing national values, experiences, and practices. So I'm at least open to the view that Cruz should be deemed eligible under an expanded understanding of the natural-born citizen clause, an understanding that reflects what many see as the modern obsolescence of founding-era concerns about potentially traitorous foreign-born leaders. But that understanding is at odds with the text, the structure, and the founding history of the Constitution to a degree that makes me uncertain that even my more open-ended approach to constitutional construction would suffice to support Cruz's eligibility without pushing the interpretive process to a level of generality so high as to be question-begging. And even if a sufficiently liberal approach would give Cruz a yes answer to the question of his eligibility, the question is anything but open and shut. So when Cruz started claiming that his eligibility was clearly settled, you can imagine that my constitutional nostrils flared, and I started seeing red. In no possible sense has the issue been settled, either by the Supreme Court or by political processes or by popular consensus, though it could eventually seem settled in that way. Worse yet, Cruz himself is the very opposite of a living constitutionalist in any sense of that term. When it comes to how the Constitution's language, even its non-technical terms like liberty, due process, and equal protection should be understood, Cruz is somewhere between a super strict textualist and a static originalist, claiming that the narrow historical meaning of the Constitution's literal text at the time of its adoption should control, except, of course, when it comes to the natural-born citizen clause, which Cruz opportunistically insists must be interpreted in an evolving way, going beyond things like James Madison's statement in 1789 that place of birth rather than parentage was decisive, to encompass things like Congress's continually changing naturalization laws, including the federal law enacted in 1790, saying that children of citizens of the United States born abroad, quote, shall be considered as natural-born citizens. The paper that the Cruz campaign recently put out challenging my arguments about the natural-born citizen clause invokes that statute and other more recent ones and proceeds as though statutes can trump, pun intended, however bad, can trump constitutional strictures. And it omits the rather inconvenient fact that in any event, the 1790 statute didn't have a very long life. It was amended in 1795 at James Madison's insistence to eliminate the words natural born, making it clear that Congress was not even trying to define those key words, something it has never, I repeat, never attempted to do. On top of that, the Cruz paper conveniently ignores the classic view that Congress's authority under the Naturalization Clause of Article 1 encompasses only a power to provide what I suppose today we'd call a path to naturalized citizenship for aliens, not a power to redefine the meaning of a presidential eligibility requirement expressly spelled out in Article 2. Now, to a genuine conservative of the sort Cruz famously claims to be when it suits his purposes, Congress has no power at all to define constitutional terms, whether they're terms of art like natural-born citizen or ordinary language terms like liberty or the free exercise of religion. Congress has no such power, and I might add that Cruz also questions the power of the Supreme Court to define constitutional terms in a binding way, conveniently leaving only Cruz himself, it seems, with that august power. Ever since Donald Trump made Cruz's eligibility a sticking point during one of the Republican debates, and to my great surprise, quoted me as having, I've never talked to the guy, as having concluded that Cruz's eligibility is far from settled, but is under a significant legal cloud. Ever since then, legal scholars of all stripes have come out of the woodwork to stake a claim on one side of the issue or another. Their conflicting views show just how unsettled the question really is, despite the decision this past Monday by the Illinois Board of Elections to include Cruz in that state's March 15 primary on the unbelievable ground that there has been a broad consensus in legal circles for over a century that everyone born to an American mother qualifies as a natural-born citizen, and that, to quote the Illinois Board in its legal expertise, quote, further discussion on this issue is unnecessary, so you can all go home. Well, that's breaking news, I must say, to quite a few constitutional scholars. For example, Professor Thomas Lee of Fordham University Law School, he did visit here, so maybe he's been infected by the Harvard bug, has recently concluded that Cruz is definitely ineligible because under common law at the time of the founding, a child born outside U.S. jurisdiction could not become a natural-born citizen through a U.S. citizen mother. It's only in 1934 that Congress eliminated the mother-father distinction from the statutes. From a more textual perspective, my colleague Einar Elhaeg has similarly concluded that Cruz just cannot be deemed eligible to serve as president under any legitimate form of constitutional interpretation. On the other hand, Brian Garner, a law professor who has co-authored a couple books with Justice Scalia, manages to find Cruz eligible by escaping the mother-father distinction and the problem of matrilineal descent through the 14th Amendment's principles of gender equality, the kind of time travel, 1868, inflecting the meaning of 1791. I do that myself. I love it. It doesn't sound very much like Cruz or like Justice Scalia. See, Garner's idea is that gender equality is part of the Constitution, although his co-author doesn't necessarily see it that way. That's doubly ironic, because Cruz's citizenship at birth definitely does not meet, and here there can be no dispute, I think, the Supreme Court's 1971 definition of a 14th Amendment citizen, which, to quote the amendment's language, gives citizenship status only to a, quote, person born or naturalized in the United States, unquote. Now, I'm not saying it would be indefensible to conclude through a hybrid form of interpretation that Professor Balkin has famously called living originalism, that somebody who's not a 14th Amendment citizen might nonetheless today be deemed a natural-born citizen eligible to run for president. I'm claiming only that it wouldn't be easy, and that it would, as David Strauss of Chicago argued in reviewing Professor Balkin's Living Originalism book, represent a kind of legal advocacy that doesn't necessarily engage with what makes one or another constitutional interpretation correct. Cass Sunstein's op-ed on this topic answers maybe to the question, is Cruz natural born as a citizen? Georgetown law professor Lawrence Solom concluded after some pretty deep digging that the natural born citizen clause may be subject to an irreducible ambiguity. I should add, it is not an ambiguity that Cruz himself could readily resolve by taking Donald Trump's advice that he seek a federal declaratory judgment. The existence of public debate that clouds somebody's candidacy this far out from the final election wouldn't seem to qualify as a ripe and genuine case or controversy, certainly not within the meaning of Article 3, as the Roberts Court has understood it. Besides, asking a court to answer the question of his eligibility would devastate his claim that there is no real question there at all. And in fact, that claim, there's no question, there's no cloud, would devastate a declaratory judgment request. It would be a request for a mere advisory opinion. To be sure, if a government official keeps Cruz off the ballot somewhere in the general election, then both Cruz and, in all likelihood, the Republican Party would have standing to take that case all the way to the Supreme Court. It's the only way to put 270 electoral votes within reach of one of the two major party nominees. It's not one the Supreme Court could duck on political question grounds. And if no government official keeps Cruz off the ballot as the Republican nominee, his rivals will all have standing to challenge his eligibility. Finally, just a word on how the 9 sitting justices would be likely to resolve the issue if and when they do decide it on the merits. Well, the more liberal wing, maybe the moderate wing, the progressive wing, the liberal wing, we have a national debate on what those terms mean and whether it matters. The liberal wing, if true to their constitutional principles, might well hold their political noses and find Cruz eligible. The conservative wing, if true to their constitutional principles, would have a much harder time justifying the conclusion that they might personally or politically favor. They could well feel constrained to find him ineligible. Sort of catch-22. Kennedy could end up, yet again, in the position of kingmaker. Last Tuesday, Cruz's wife, Heidi, told a reporter that the way Ted relieves tension during anxious campaign moments is by singing show tunes. He calls on her cell phone and, without warning, breaks into a Broadway song. And when I read that, there was one image that came into my head right away. It's an image I haven't been able to shake. I can almost hear it now. It's Ted Cruz serenading us all, maybe on Saturday Night Live, with the great Aaron Burr number that Lin-Manuel Miranda used to open Alexander Hamilton. Thanks very much.
We're going to break very quickly to pick up burritos.
We'll put them on both the aisles here, so if you could please clear this first row, and then we can go on Professor.
Hey guys, how are you? How are the burritos? Good? All right, fine. I was thinking why a constitution is like a burrito. And then Larry said, you should think about why it's not like a burrito. We'll debate that later. That'll be our second debate topic. I am here to tell you how an originalist would think about the question of Ted Cruz's eligibility. Because believe it or not, I am an originalist. Now, I'm a living originalist, so that's a little odd. But nevertheless, I think I can make the argument for not just my version of originalism, but many other people's versions too. And in fact, the claim I'm going to make is it doesn't matter which version you are, whether you're my version, which is the right version, or whether you're a different kind of originalist. In fact, you'll probably come to pretty much the same place. OK? That's basically what I'm going to do. Watch closely. My hands never leave my wrists. The idea is really simple. Most originalists, really since about the 80s or so, have been what we might call original public meaning originalists. That is, they argue that what is binding, see, the real question is what's binding on you today? So they argue that what's binding on you today as law is the original public meaning of the constitutional text. Okay. So I'm that kind, and other originalists are that kind too. There are a small number who aren't original public meaning originalists, but most of them are. Now, the next thing you have to understand, and it's really, really important, it's like the most important thing in understanding how to think about originalism, is that the original public meaning of a text is not the same thing as how people expected that that text would be applied to some concrete controversy. That's really important. The original public meaning of the text is not the same thing as how people expected it would be applied. That's what we call original expected application. Now, my book makes a big deal about that distinction, but I just want to point out that after reading my book, most originalists now agree with me. So they also agree that the original meaning of the text is not the same thing as how people at the time expected it would be applied. The big difference between originalists is not that question. The big difference is how thick or how thin we cash out the idea of original public meaning. So I am, despite my girth, a thin original public meaning guy. Okay? And my good friends in the Federalist Society and elsewhere who are originalists, some of them are a little thicker than I am. Can you believe that? And some of them are still thicker, and some of them are quite thick indeed. Right? So the distinction is between thin and thick. Now, my version is that the original public meaning is the original semantic meaning of the words in the text or phrases in the text. Any legal terms of art, which you can't tell from looking at the definitions of the words or phrases. So those would be like legal terms like bill of attainder, as Larry said. And then finally, any background context you need to understand what the sentences are saying. So for example, when it has numerals, those numerals are in base 10, right? Not base 12, that when it refers to calendar, it's the Gregorian calendar. It's not the Jewish lunar calendar. So basically, the idea is it's very stripped down. It's very thin. What were the words mean at the time? What the phrases mean? What do they mean in context? Are there any legal terms of art? And basically, we go from there. Everything else that isn't solved by that has to be built out over time. It has to be constructed. OK? That's construction. Example, equal protection of the laws. Words equal protection of the laws in 1868 mean something. They mean the same thing today. The words haven't changed their meaning. But how we apply equal protection of the laws, for example, to women's equality is different. That is, the people who wrote the 14th Amendment did not expect that it would change the common law rules under which women lost all their rights when they got married. But that doesn't tell you what the original public meaning is. That's just how they expected it would be applied. Today, we can say the original public meaning is equal protection of the laws. And they believed that there shouldn't be class legislation, there shouldn't be caste legislation. If we apply these principles today, sex equality for women, not a problem, even though they would have disagreed. That's the distinction, OK? Freedom of speech. Doesn't matter what they thought freedom of speech meant in practice, how they thought it would be applied. What matters is the word freedom of speech means the same thing today as it did then. We have to figure out what it means today. So that's a thin version of original public meaning. Now, some of my friends, originalists, good originalists, disagree with me. They want a thicker conception of original public meaning. And what they mean by that is they say, let's go back in history and look at the examples that were offered and the principles that were offered and the sort of policies that were at stake. And those are still binding on us. They're baked into original public meaning. Now, the problem with thicker versions is the thicker you get, the more difficult it is to legitimate a modern state. You can't have a modern state either at the state or federal level. You can't have a modern presidency. You can't have modern civil rights law. You can't have modern civil liberties law. Basically, the thicker you get, the more impossible this becomes. And this creates a serious problem of democratic legitimacy in the present. Remember, originalism is about legitimacy. It's about establishing the legitimacy of law. So you have to not only maintain legitimacy at the moment that law is made, you have to maintain legitimacy over time. So the thicker you get, the more you have this problem. So that's why most originalists aren't totally thick, right? They have some version. They're somewhere between thin like me, and some are even thinner than me, but can you believe that? And some are thicker than me, but that's basically the idea. And we can talk about that more, but I just want you to give you the idea that that's what the debate over originalism is now. It's about thin or thick versions of originalism. I'll give you an example. So Justice Thomas, who is an originalist, original public meaning originalist, he is a much thicker originalist than I am. And he wrote an opinion involving violent video games, the Brown case. And in it, he said, look, I did some research. I figured out that at the time of the founding, children were not to speak. They were to listen. And no one could talk to your kid unless you gave permission. So from this, he concludes that at the time of the founding, freedom of speech did not apply to minors. They had no free speech rights, and nobody had a right to talk to them either, unless their parents gave permission. So his view is, who cares whether or not violent video games are speech, because kids have no free speech rights, and that includes people up to the age of 18. No free speech rights at all. I think that's too thick. I think that's a confusion between the meaning of the word, freedom of speech, and the original expected application, how people expected it would be applied. That's too thick an account of original public meaning. And I don't want to get into who's right or who's wrong. It's just that I'm right and he's wrong. But I just want you to see how this works, OK? And that's the big idea I want you to take away. Larry's done almost all of the groundwork for my discussion, so it can be very quick. He told you about the history of the phrase natural-born citizen. He told you about the statutes in 1790 and 1795. He told you about a stray quote from James Madison. It's always nice. But I'm going to approach the question slightly differently. So is the term natural-born citizen just like equal protection of the laws, or is it a term of art like, say, a bill of attainder? Well, everything that I've been able to figure out suggests to me that it's a legal term of art. And therefore, we have a slightly different analysis. We ask, what would a lawyer think it meant in 1788 instead of what would an ordinary citizen think it meant? So for terms of art, we ask what a professionally well-trained lawyer would think. A professional well-trained lawyer would reason as follows. They would say, well, we are a republic. We're not a monarchy. they did have this thing in England that was called a natural-born subject. So this is probably like a riff off of the English concept of natural-born subject. And we know a couple of things about natural-born subjects. One, it's based on the idea that there is a reciprocal relation between the sovereign and the citizen. The sovereign owes allegiance, and the citizen owes allegiance, and the sovereign offers protection of law, right, to the citizen, right? That idea. And so the real question is, how far does the sovereign's protection extend? And the common law, old common law rule was it was largely confined to the place where you were born. If you were born within the sovereign's territories, then you had that reciprocal allegiance. But it also turns out there were exceptions made for diplomats, as Larry said, and for people fighting the king's wars. And it also turns out that Parliament, starting in the 1600s and through the 1700s, repeatedly changed the legal definition of natural-born subject. First, because of the English Civil War, and later to deal with problems of empire. So we know that if you were a well-trained lawyer in 1788, you would have known all this, and you would have realized that it's a common law idea that can be changed by Parliament through statute, and that it was changed through statute repeatedly, and that the question then would come, we move from a monarchy to a republic. And the question is, as we move from a monarchy to a republic, there are a couple of things that change. First of all, one is the power, where power is lodged. And the second question is whether or not there's a constitutional idea as opposed to merely common law idea. So let's take the first one first. So in Britain, basically the sovereign is the king and parliament. So the king and parliament pretty much can do anything at once. They have parliamentary sovereignty. But in the United States, we have popular sovereignty. So we delegate powers to the states and to the federal government, and we delegate powers within the federal government to the various branches. So we cannot simply transfer what they had in Britain over. We have to ask, how does it fit into our scheme? And so the question we have to ask is, who had the power to define citizenship in the new federal scheme? And the answer is Congress does. Congress has a power of naturalization, a uniform rule of naturalization. Parliament had two kinds of naturalization. They could make someone a citizen who had been born in another country and was not a subject of the king. And they could also declare who was a natural-born subject. They had two naturalization powers. So the question is, when we look at the American Constitution, which includes all of the powers together, when you take the three branches and the states together, all of the powers, they're vested somewhere. Where are these two naturalization powers vested? The answer is they're vested in the American Congress. And that's actually a good idea. It makes sense why. Congress is the democratic branch. Congress is the representative branch. We live in a republic. To decide basic questions of who's a citizen and who can be eligible to be president, we would rather place that in the democratic branch, the representative branch, in Congress, so it makes sense from the standpoint of structure. Okay, next question. Is it a common law? What happens when you take a common law term and you move it into a constitution? So one possibility is it's fixed and frozen for all time. Therefore, whatever it turns out the meaning was at the time is fixed forever, right? That was really Larry's originalist argument, okay? I don't think so. If you think about the structural argument I just made, right, it's an argument from structure. What's been transferred over constitutionally is a common law baseline and a power of Congress, of Parliament, now a power of Congress. So what gets transferred over is there's a common law baseline of what a natural-born citizen is, which isn't really worked out at the time. It's really basically an assumption. It's about some relation. You have to have a connection to the republic. And the most obvious way you demonstrate the connection to the republic is being born there. And then it's also true that there are some common, even in the common law, there were various extensions. So it evolved over time. And then Parliament, now Congress, has the power to expand it, as long as Parliament or Congress is assured that there is a sufficient connection between the person and the state, that is, because it's in the republic in our case. So if that's the case, then the correct reading of the clause today is there's a common law baseline, which has now been changed, by the way, by the 14th Amendment, been constitutionalized by the 14th Amendment, birthright citizenship. And then Congress has the power to expand, in the same way Parliament had the power to expand as it did in the 1600s and 1700s. And there may be a limit, by the way, to how far Congress can expand natural-born citizen. I'll talk about that in a second, but I just want you to understand that the way to understand the clause is structurally. It's not like equal protection of the laws, which is a rights provision. It's a structural provision, and it invokes Congress's naturalization power. You read natural-born citizen against the naturalization clause in Article 1, Section 8. That's the correct way to understand it. If that's the case, then the question we have to ask is not what was the law in 1788. The question is, what's the law in 1970 when Cruz is born? And the law in 1970 was that if one of your parents was an American citizen and had established residence to a certain amount before birth, and you, in turn, established residence, then you're a citizen. And you're a citizen by birth. This is part of the citizenship statutes, which tells you who's a citizen by birth, not who can be naturalized a citizen. And that makes perfect sense structurally. Congress has two naturalization powers. It has a power to make somebody a citizen born somewhere else, and it has the power to decide who's a citizen by birth. Just as Parliament had those powers, Congress has those powers. Okay, so that's the basic idea, and that's why it's not really a difficult problem whether Cruz is a natural-born citizen. Congress, using its power under the naturalization clause, said he is a citizen by birth, he fits the terms, he's a citizen by birth. Now you might ask, well, what about natural-born citizen, right? I just left out the key word, natural-born citizen. But here's the point. Natural cannot mean as opposed to statutory. Can't. The reason why is because Parliament made statutes that changed the meaning of natural-born citizen. And any English lawyer at the time would tell you you were a natural-born subject, even though it was a result of a statute. So the distinction is not between statute and common law. Doesn't make any sense. Anybody who understood the history would realize it made no sense. What does natural mean? Well, it's part of a clause. It's part of a word. It's part of a phrase. It must mean something that's either a play on natus, born, birth, right? And nature, that is automatic. So a natural-born citizen is someone who becomes automatically a citizen at the moment of birth. They don't have to do anything else. They don't have to fill out a form. They don't have to do a fancy dance. As soon as they're born, by operation of nature, they are automatically a citizen. So this is the pun on natus, birth, and natural, automatic. And it's tied, interestingly enough, to the other part of the text, the power of naturalization, to make someone a citizen of the United States. OK, that's fine. There are a few more bells and whistles I want to talk about. But now I want to come back to the place I started. I said, Larry said, I'm a special kind of originalist. I'm a living originalist. I have a very thin conception of original public meaning. But here's the kicker. Here's the thing I want you to understand. Even if you don't have as thin a conception of original public meaning as I do, even if you have a thick conception, like my good friends do, or even if you had as thick a conception as Justice Thomas did, you could look at the structural argument I just made and nod your head as to every step. There's nothing in even a thick account of original public meaning that prevents you from making this structural argument and recognizing that the power of naturalization resides in a republic in the United States Congress. And therefore, even though I am a very special kind of originalist, the right one, it's also true that all my other friends who are originalists could listen to my argument and say, you know that Balkin, he's making sense. I disagree with him on gay marriage and everything else, but on this we agree because he knows how to make a structural argument. That's the big idea. One more point. I have a very good friend, former student, Jack Chin. He teaches at UC Davis. And he sent me an email, and he said, you know, there's one problem with your argument. And since there's a problem with the argument, I got to tell you what it is. Because, you know, in law, arguments, no argument is ever foolproof. The arguments just keep going. That's just the way law is, you know? He said, look, there's something really funny, weird about the statute that was in place when Cruz was born. It had a sort of condition subsequent to it. That is, you had to, your mother had to have residence for a certain amount of time, and in fact, she did. But you, sometime between the ages of 14 and 28, had to live in the United States continuously for a period of 5 years. What that meant is that you couldn't, like, every year go off to some other place and then come back. You had to actually be rooted in the United States for 5 years, sometime during this period between 14 and 28. Now, as far as I know, Ted Cruz did that. Now, if any of you want to dig up how many vacations did he take in France, go ahead, be my guest. But my understanding is that he met that. And Jack made this really interesting point, and it's really important. So it's against my argument. That's why I have to tell you about it. And he said, look, You could lose your citizenship if you didn't establish 5 years of continuous residency in the US between the ages of 14 and 28. Now, how can you be a natural-born citizen if at some point in the future you could lose your citizenship? So he says you should only regard such a person as a provisional citizen, not a natural-born citizen. And therefore, Cruz loses. That's what Jack said to me. And I thought about it for a while, and it seems like a very powerful argument. But as you know, in law, there's always a counter-argument, right? So this is my counter-argument, and this is what I leave you with. The question of whether you're a natural-born citizen means is the question of whether or not you become a citizen automatically at birth. You could be a natural-born citizen and still lose your citizenship. Now, usually the way you lose your citizenship is to renounce it, right? It's very rare in American constitutional law. Actually, Larry knows more about this than I do, because he's written about it, that there are a set of cases in which Congress tries to make people lose their citizenship, and the Supreme Court generally doesn't like to allow people to lose their citizenship unless they affirmatively and positively say, I don't want to be a citizen anymore, right? So this would be an exception to the general principle of constitutional law, which is that we try very hard not to have people accidentally lose their citizenship. But there are examples. So when you think about the case of women, for many, many years in the United States, if you were a natural-born citizen in the United States and you married a foreigner and went to live across the seas with that foreigner, you lost your citizenship upon marriage. And that was the rule for a very long period of time. So it's not crazy that Congress could, in fact, snatch citizenship back. But that doesn't mean that the people who were born in the United States, women born in the United States who married people from other countries, were not natural-born citizens. It doesn't affect their natural-born citizenship at all. And in the same way, I don't think the fact that Cruz had to show up and live for 5 years at some point between 14 and 28 means that he wasn't a natural-born citizen at the time he was born. He was. But Congress said, and we want something else from you, or else you'll lose your citizenship. That may be a bad idea as a matter of policy. And in fact, it's also plausible, although we don't have time to talk about it, that there might be a constitutional problem with snatching back citizenship once granted in these contexts. But I don't think it touches the question of whether he's natural-born. Thank you very much.
Great. Let me just say a couple of words and then open it up. I agree with almost everything that my friend and other former student, Jack Balkin, said. I think he's right up until the point.
If it helps you, I was asleep in the class most of the time.
No, I think you learned even more than I taught. But it seems to me that the place the argument goes off, well, there are two places. One, when you look at structure, there is a fundamental structural difference in American understanding between Parliament and Congress. Congress is a body of limited powers, not only those expressly delegated, those delegated with a kind of McCulloch v. Maryland penumbra will do as well, but it has limited powers. It does not have the powers of definition that a lawyer in England or the United States would have thought that Parliament had. And that makes a huge difference. I mean, cases like City of Burney against Flores, even when Congress is exercising an enforcement power to enforce the 14th Amendment, people across the range of the Supreme Court, they may have differed about religion, but they didn't differ about what I think was the misguided decision by Justice Kennedy to say that Congress's enforcement power includes no definitional power. Now, we don't have the time without totally preempting Q&A to go more deeply into that, but that's where I differ with Jack. That's why I included in my original remarks the idea that the power of naturalization was understood here in Article 1, semantically at the time and really ever since, as a power to define a path to citizenship for people who were not citizens at birth. Now, it's true that naturalization powers belonging to Congress were of a more capacious kind and included the power to define who would not have to go through any process, but who would just be a citizen at birth. But as Einar Elhage has pointed out, if citizen at birth were the semantic meaning of natural-born citizen, then the word natural is doing no work at all. That is, it clearly did mean something more than a born citizen. It meant something more. The only other point I want to make is that I think the other Jack has the slightly better of the argument, the UC Davis Jack, than this one, because I too have focused on the fact that the kind of citizenship Cruz claims to have acquired in 1970 through his mother was defeasible. He could have lost it. It's true, he, in all likelihood, didn't do what the law would have required him to do before losing that citizenship. But it seems, and in fact, after 1978, many of the requirements of 5 years of continuous residency were relaxed and in some cases eliminated. But it does seem to me that it is a fundamental problem with the idea that you're a natural-born citizen, that this is a citizenship that is contingent and conditional and subject to loss. When the Supreme Court, in the cases that Jack adverted to, Rogers v. Belli, Schneider v. Rusk, and other cases, said that there are limits on the ability of Congress to strip your citizenship after you've got it, it drew a distinction between people who got their citizenship by being born here and people who were naturalized here. And just as there could be a condition precedent to naturalization post-birth, there could be a condition subsequent to naturalization at birth. Now, the only point of going into this depth of detail, which I don't think the Illinois board exactly had in mind earlier this week, is that it underscores my point that this should not be regarded as open and shut and settled. Now, Jack is very persuasive. He's brilliant, and he makes a very powerful argument. But I don't think he really believes, do you, Jack, that it's not a question subject to debate?
Well, it involves lawyers.
And that, by definition, is subject to debate. OK. Yes, it involves lawyers and clever lawyers with political ambitions. Anyway, let me stop here. And the reason they put two podia here isn't that I really need to, but that if you want to be up here while we have a dialogue, you can too. And then you should direct your questions either to one of us or to both of us.
Sure.
Or to neither of us.
I guess a question for both of you. In addition to the question of what does the Constitution mean, I'd be interested if you had any opinions on how the court would actually implement that meaning. I think, Professor Tribe, you spoke to the fact that it might be difficult to have a declaratory judgment by Cruz. You did seem to suggest that some candidates, but not an average citizen, could establish Article III standing.
If the candidate is really harmed.
Right.
That is, like Cruz is a candidate, not an ordinary citizen, but I don't think he has standing yet.
So
there isn't a ripe controversy
if,
yet.
Hypothetically, no one established Article III standing or sued in court until after, say, Cruz became president, what would the Supreme Court do? Would it not do anything under political question?
They would find a way to duck.
So they would duck it, or would the vice president move up to the president's slot, or would the entire ticket be invalid?
If they said the president is not legitimate, remember, Cruz has said he doesn't feel bound by what the Supreme Court says. So we might have quite a crisis if that happened. But if the Supreme Court said he's not a legitimate president, then presumably he would step down and the vice president, Palin, or whoever it might be, would step in. But it seems to me that the pivotal point at which the issue could arise is if any of the 50 states say you can't get to, you have to build your 270 electoral votes without our participation. We're not putting you on the ballot. Then clearly he would have standing to challenge it. And the idea that the court would say, well, you know, it's a political question whether they have impermissibly deprived the people of the chance to vote for you, that's quite unthinkable. Mm-hmm. Off the wall, as
off the wall. It's off the wall. No, what they'll do is they'll do everything possible to avoid deciding the question. The reason why is because they really want to kick it to Congress when the electoral votes are open. There's a possibility at that point for somebody to raise a challenge. The challenge, in fact, would not be accepted. Congress would simply go through with it.
Right. Except I thought that in Bush v. Gore as well. So
I know. It's just crazy.
I know.
These things happen.
I mean, I just about fell over when I got a call from the clerk saying, "Are you sitting down?" And then the court intervened. There was also a political process through which Congress could resolve competing slates, but the court didn't do it. Yeah. I think that they may have learned their lesson, that they won't do Bush v. Gore redux over this. Jessica?
Hi, Professor Balkin. I understood your structural argument to be saying that basically there's a textual constitutional commitment of this issue to Congress, and that makes sense to me in the cases where it's about like how Congress operates itself. But it seems like there's some high-level separation of powers things going on here where you're saying Congress has the power to decide a question that's rooted in Article 2, and I was wondering if there are other constitutional provisions about Article 2 or 3 that you think are committed to Congress? Like, do we just see this problem somewhere else?
Yeah, I mean, to be more precise, what happens is you've transferred over the power of naturalization to Congress that used to be in the British Parliament, both kinds of naturalization. And so Congress has some leeway, but it's still possible that Congress could, in fact, overstep its power to make people citizens by birth. So let's take the paradigm case. Paradigm case is Vladimir Putin very much wants to be president of the United States. And so what happens is he bribes enough people in Congress, and they make him a natural-born citizen. Now, my view is that that probably is beyond their power, right? He doesn't have any connection to the country. And therefore, I would argue that there's a separation of powers issue. The court has the power to say that's an unconstitutional extension. But what Article 1, Section 8 does is give Congress a certain leeway to define who's a natural-born citizen. It can't go less than the 14th Amendment, which has solved the old question of where does it stop. 14th Amendment is a baseline. And it can't go further than a certain point. Okay? Now, as to the question of whether Congress has legislative power with respect to presidential qualifications and succession, the answer is yes. Even in the 1787 Constitution, Congress could decide what happens when the president dies, who becomes the next president, and if the vice president dies, who becomes the next president. And that is altered again in the 25th Amendment. And the 25th Amendment also reiterates that Congress has the power to set up what are quasi-constitutional rules of succession. So the idea that Congress would have this role of basically deciding who can become president is not a crazy one if you think about how the structure is organized.
Right, except there I would invoke Article 1, Section 8, Clause 18. I would say that that's necessary and proper to the effectuation of the presidency. Now, take a thought experiment. Suppose, given how many people in Congress apparently are not exactly fond of Ted Cruz, Congress were to pass by an overwhelming majority a law saying Ted Cruz is not a natural-born citizen. Now, maybe it's a bill of attainder in violation of Article, but is it a punishment not to be president? The court said even
that's a really interesting question.
I think it's a punishment. It's a punishment to be president. When Barack was, when he won, I thought he should have asked for a recount, because But seriously, if it's not a punishment to expel someone from the country, as it isn't under current law, I think to exclude someone from the presidency may not be a bill of attainder. But even setting aside the bill of attainder, I think that suggests that there are structural limits, like the limit on trial by legislature, on Congress's powers here. And I think that if Congress does not have a free-floating power to define natural-born citizen, any more than it does to say, what does the number 35 mean? Is it in base 10 or base 12? It doesn't have that power. Then I don't know how it gets precisely the power that my friend Jack says it has.
Maybe one more?
Thank you very much. I had a question about Solom's piece, and if the overall conclusion was that it's deeply ambiguous. How did he differ from your interpretation?
You have to ask Larry, since Larry's more familiar with
not this Larry Solom.
Yeah, you have to ask Larry about Larry's article.
And in that case, was it too thick? Was it too thin? I'm just trying to grapple with that idea.
I think it may be along a different axis altogether. I mean, he has the notion, which I think may make sense, that there are certain indeterminate questions in the Constitution. I mean, for example, reading the Constitution literally thick or thin, it would make the vice president preside over his own impeachment trial in the Senate. That can't be. So not only as a matter of constitutional silence is it indeterminate, it seems to me that Congress filling in gaps is a different thing from Congress simply pulling a rabbit out of the hat. I think it is an indeterminate question. What should happen, what would be permissible if the vice president of the United States were impeached by the House, at which point the Chief Justice of the United States is not authorized to sit, but rather the President of the Senate, namely the Vice President, as presiding judge at the trial.
Let me see if I can explain it, get to what your question is about. So it's possible that a constitutional term could be vague. That is, we don't know how far it extends. And it's also possible it could be ambiguous. That is, we don't even know what concept we're pointing at. So if Larry Solom concluded it was irreducibly ambiguous, that would mean that there was no fixed original public meaning, except within some boundary. And then the question is, what are we going to do? And then ordinarily what we would do at that point is engage in constitutional construction. We would use the various modalities of constitutional argument, the ones that you know how to do, all lawyers know how to do, and we would try to come up with the most satisfying solution to the problem. That's what we would do in a case of irreducible ambiguity. But if it's but vagueness is a slightly different problem.
But in that circumstance, then would the default rule with respect to natural-born citizens would be to exclude someone from
No,
the
not
ballot? Or
necessarily,
just-
no.
Oh, there would be no sort of set
I think
principle.
the most important takeaway has nothing to do with Ted Cruz. It has to do with the fact that at least the two of us agree with almost everything except the last line or the last syllable of recorded time. That is, it seems to me that what you really need is a very thick originalist to make the other argument, saying that there's no way that he's eligible. Or take somebody like Einar Elhage, who's quite agnostic about methods of interpretation, but you can find his piece about this online, and he says there's just nothing that counts as interpretation of any stripe that would make him eligible. But again, I come back to my own bottom line. If the views are that scattered among people who've thought hard about it and from a kind of nonpartisan perspective, then at least can't we agree that it's not well settled?
Professor Balkin, Professor Tribe, thank you both very much.